This is an appeal in the matter of the London Borough of Wandsworth and Jerome Young.
Elisabeth.
Morning. My lord, my lady, I appear with Mr. Griffiths on behalf of the appellant Mr. Young and my learned friend Mr. Hutchins, King's Counsel appears for the local authority. By way of housekeeping, can I just check you have an appeal bundle that runs to 339 pages?
Yes.
Excellent. And an authorities bundle with 25 entries, hopefully found weighty as well.
Yes.
Splendid. Skeletons from us both.
Yes.
In, no doubt, multiple copies thereof in bundles lodged separately, etc., etc. And then this morning, we were provided last night with the transcript of the argument at the commission hearing, which we've handed up as well.
Yes.
That, I think, is largely for completeness. Having been flagging that we've been hunting it, handed in, I don't really think we're looking at it very much. And take it from there. My lord, my lady, this is a case about eviction from temporary accommodation provided by the local authority to Mr. Young under Part 7 of the Housing Act 1996. My case is that Mr. Young was still owed an extant housing duty by the local authority as at the date of the possession proceedings, indeed the possession hearing, and he was entitled to raise that extant duty as an answer to defeat the claim for possession. That argument did not succeed before the district judge or the circuit judge for a variety of reasons, and I hope both judges below will forgive me if I don't spend an awful lot of time on their decision because it's a pure point of law. And the arguments now advanced are, whether they're any better or not, it's a different matter, but they're somewhat more refined than they were below. And my learned friends taking a respondent's notice point upholding part of the district judge's decision and not the circuit judge's decision. So I hope that the judges below will forgive me if I don't spend an awful lot of time.
Just before you develop your arguments, Mr. Hutchings helpfully says in his more recent skeleton argument, I'm raising a new point. Yep. I assume there's no objection to that.
I have no objection whatsoever. I'll put on the record a discussion my friend and I were having outside. As far as humanly possible, neither of us are going to try and take pleading points, procedural points, etc. We both obviously have a case we are submitting to you as to what the answer should be, but just standing back for a minute, this is one of those questions that housing law needs the answer to. For the benefit of housing law as a whole, the answer is needed. Obviously, we will each advance what you say is the correct answer. But having been presented with an opportunity to answer a question that hasn't actually fallen to be addressed since the 1996 Act came in, it seems to us it would just be silly beyond words to waste that opportunity to have that important question decided. It also ties in, as I'm sure my lord has picked up, with the decision of my lords from earlier in the summer, the Banno case, which I'm not sure if my lord's kept informed of this, but that's now listed on the 17th of March.
I didn't know when it was listed. I knew that
yes,
permission had been given.
Listed on the 17th of March. And whilst I know I want to prejudge decisions, nor do I want to presuppose that I can make any particular demand on the court's time for writing judgments, you'll have seen from the permission decision and from the permission transcripts handed up this morning, one of the things that is in the background here is the possibility, and I put it no higher than that, of this case catching up with Banno, because it raises a similar issue, but in a different part of the legislative scheme. And it seems to us there is a possibility, and again I put it no higher than that their lordships may want to consider this with Banno. So for that reason, if no others, we are trying to get to the answer here. And we will both do our best to avoid descending into punitive points. But the short answer to your question is no. I'm taking no points about, what is it, the Notting Hill Finance and Shake case about new points. So.
Yeah.
The way I structured my argument, as you'll see from the appeal bundle, page 30 in my skeleton, if I can just take you to that. Is on 4 propositions. The first 2 are not in dispute. So the position is that Mr. Young had a non-secure tenancy of the temporary accommodation which he was occupying. Because it was being occupied pursuant after the 1932 duty had been accepted, it's occupied as a dwelling, and therefore the Possession and Eviction Act applied. That is why a possession order was needed. Because a possession order was needed, the second proposition arises, which is that non-secure tenants, in broad terms, have two categories of defence to a possession claim. One is their private law rights, the notice to quit doesn't give enough days, wasn't served on me, whatever. But the other, where the claimant is a public authority, is the public law defence, sometimes called the Winder defence, sometimes called the Gateway B defence. Terminology has changed over the course of the case law. But the essential proposition being that a point that could be taken by way of judicial review can also be taken by way as defence to a claim for possession proceedings. Both of those propositions are not in dispute. It's the third and fourth propositions that are the focus of this appeal. And in terms of how I'm going to present the appeal, I think it makes more sense to reverse propositions 3 and 4. So the first thing I'm going to address you on is proposition 4, which is, was Mr. Young owed any duty at all? Because if it wasn't owed a duty, an interesting discussion about public law defences doesn't really arise. So on proposition 4, this will turn on what, if anything, the local authority had to notify to Mr. Young before the duty could end under section 193 sub 6 of the Housing Act 1996. And our submission is that what is required is notification of the decision that the duty has ended, plus notification of the right to seek a review of the decision that the duty has ended. The learned friend says that's wrong, and that's proposition 4.
And just talking on that for a moment, the plus bit is crucial to your case.
It is, absolutely. I have to win on both parts of what I just submitted, yes. It doesn't help me to only get home on the first part. I have to get home on both. The answer to proposition 4 in my submission is primarily going to be a question of statutory interpretation. There is no authority directly on point. There is a decision of this court called Banno and Waltham Forest, decided earlier this year, which I will accept is relevant and I will accept is obviously very helpful to me. We do have, as you've seen in the skeleton, a way of distinguishing it. I cannot submit it is wrong, and I know I'm talking about that side. I cannot pretend Young and the Bristol aeroplane is satisfied. So I have to start on the assumption that it is correct, but does not govern this scenario. As we say in the skeleton, and as I'm sure my lord and lady appreciate, I do have to reserve my position as to whether it is correct or not, but for these purposes, it is the law, and I have to proceed on that basis. If I succeed on my proposition 4, then proposition 3 arises. So at proposition 3 stage, the position is that the 1932 duty is still owed, and that it provides a defence to a claim for possession. My learned friend says that's wrong. He says the vehicle by which I had to ventilate that argument was by way of a section 202 review, and then section 204 appeal in due course. As I said, although in the skeleton I've done 1, 2, 3, and 4 in the usual chronological numerical way, it does seem to me actually on reflection it makes more sense to do proposition 4 first, because if there was no duty, then the arguments about alternative remedy aren't going to arise. So I'll address them in that order. Was there an extant duty, and did it provide a defence to a claim for possession? Before I get into that, though, there are 2 areas I need to explore, it seems to me, before I get to my fundamental submissions. The first is I do need to spend a bit of time taking us through the factual material of all this, because A, it's important to look at the actual correspondence and the letters. Secondly, because, as is sadly commonplace with Hamlet's decisions, we have various false starts that go off in different places before we get back to the true path of all this. So I'll take you through the key events there. And secondly, I want to then, before I come to the main submissions, address my learned friend's final point in the skeleton, which is his so what point. What am I actually seeking to achieve? Because, and I have to be frank about that, there are oddities about this case. The oddity being, we, on the face of it, accepted an offer. There is an unappealed finding that we had capacity to accept that. So I want to deal with that before I get into the meat of the argument. My learned friend puts it last, but it seems to me I should address it first. My hope is I'll be finished comfortably before the short adjournment, but one never knows. I will do my best. So, in terms of the factual materials, you have in our skeleton at page 31 of the bundle the cross-reference provisions of the various parts of the skeleton, various chronological events. I don't want to take you to all of them. I'll try and take you to what seems to be the key ones. The first one is paragraph 5.1, Dr. Suleiman's August 2019 report. Because notwithstanding the finding of capacity, which I do not challenge, have not sought to challenge, understanding the practical reality of the position this man finds himself in my submission becomes quite important. So Dr. Suleiman's first report from 27th of August 2019 starts at page 304 in that bundle. It is a very long report detailing his very difficult personal history from childhood and school years onwards, his psychiatric history, his engagement with various healthcare services. And I do ask, and in due course, the court to flick through that to get a flavour of it. But with allowing the time and making best use of time today, if we jump to page 327, Dr. Suleiman pulls the material together. You see at 7.1.1, he forms the view that Mr. Young lacks capacity to understand the court proceedings. He struggles to understand advice given by his solicitor. Very concrete thinking, struggles with abstract concepts, upset if his solicitor's views don't match his own, rigidity of thinking, difficulty controlling anger, impulsively changes his solicitors. And part of the reason for that is 7.2. He has a diagnosis of autistic spectrum disorder, traits of attention deficit hyperactivity disorder, developmental disorders starting in childhood, and those are explained in more detail earlier on in the report. 7.2.2 struggles to socialise and communicate, finds it hard to understand intentions or instructions, struggles with changes in routine. 7.2.4 struggles with daily life activities, requires support from his female friend with cooking and replying to letters, struggles to communicate, relationships are affected. With the benefit of Mr. Flack, his solicitor, as the district judge judgment rightly notes, Mr. Flack's significant involvement here, he manages to make the application to a local authority, and on the 3rd of September 2019, I'm back on page 31 now for the chronology, he's granted the non-secure tenancy of the property from which the authority will subsequently try to evict him. On the 10th of October 2019, the authority determined that they owe the full main or 1932 duty. The letter accepting that duty is at page 215, if we could jump to that. You see the first paragraph, something further to your application. The authority reaches their conclusion that the various component parts of Part 7 are satisfied so that the 1932 duty is owed. They explain the consequence on the second paragraph. They accept the 1932 duty. They explain in the third paragraph how we should make contact with the authority. You may have picked up there's been some unfortunate involvement with local authority officers. Sorry, do you want to... Yeah. Turning over to 216, under the heading temporary accommodation. Explaining there that he's going to stay in the same property we just move from 188, the temporary accommodation provision, to 1932 until the 1932 duty is discharged. Well, then a friend asks me to draw attention to the bottom of 216, the offer of accommodation to bring duty to an end. There is a one reasonable offer policy in respect of offers made to end the duty, description of the kinds of offers that it may be, i.e. council tenancy, housing association tenancy, or private sector property. It draws attention to the fact that the offer could be within the authorities area or some other area. Any other bits of that? Yeah, I've got that now, I'll do that. Yeah, thanks. And then at the bottom of 217, one I flagged already, circumstances in which the council's duty to house you may cease. I just draw attention to the word may. It may cease for a number of reasons over the page. 8 bullet points. The third is the one that will eventually be relied upon in this case. Now, unless there's anything else I have to draw attention to, that's all I'd be taking you to in that letter. I suspect it follows a format that everyone is very familiar with. I'm just pausing here for a minute because I suspect this is an issue that will come up certainly in my friend submissions. Those 6 bullet points there in my submission, none of those can be described as decisions or notifications. Those are merely descriptions of circumstances which may end the duty. Returning to the chronology on page 31. The next date is item 4, the 18th of March. The offer of the property to which he never moves in. That offer is at page 219, and again we need to go to that, I'm afraid. You see on the front page, it's an offer of 25 Diprose Lodge, under what will initially be an introductory tenancy and will subsequently become a flexible tenancy. These are simply forms of social housing tenancy. Introductory tenancies are, in very broad terms, a 1-year trial period. And then at the end of your introductory tenancy, there are, again in very broad terms, 2 routes an authority can go down. They can grant you an old-style secure tenancy, periodic tenancy, effectively for the remainder of your life, so long as you meet conditions. Or, post-Localism Act, they can grant fixed-term secure tenancies called flexible tenancies. So it's an offer, effectively it's an offer of a 10-year fixed-term tenancy. That is a property which the authority considers to be suitable. The last line of the first paragraph, stopping this letter is formal notice. That's a red herring. Although it refers back to the 1996 Act, that's a notification provision to do with where you move from introductory to flexible. It's got nothing to do with homelessness, despite using the language of notification that arises in our case. The important bit is the bit in bold underneath it. By accepting the offer, the council's tenancy duty will be discharged. And then over the page, it's largely, that's my friend wants me to draw your attention to anything, it's largely descriptive of the process to be offered, viewing arrangements, what the rent will be, etc., etc. And just pausing on this as well, my submission is, this is simply a letter offering a property which the authority considers to be suitable. It's not a decision that an extant duty has ended. So before I move on to the loan for analysis, ask me to draw attention, and I'm quite happy to do so, to what's on page 223, just above the second bullet point. When making this offer, they've taken into account your personal circumstances assessed at the time of your application. To go then changes satisfied as suitable.
Sorry, I've now lost you.
Sorry, my
We're
loan
at
for
223.
So 223, above the second hole punch, when making this offer, the council has taken into account your personal.
Yes.
And he asks me to draw attention to that paragraph, in particular the last sentence.
Yes. I mean, as I understand it, there are various passages along the same line. So if you go to the previous page, halfway down it says, we will normally make applicants only one suitable offer, and if you refuse, your application will be cancelled. And then you get the final offer bit at 223. And at the bottom of 223, please note if you unreasonably refuse, the duty will cease.
Yeah.
And then over the page.
And over the page.
Should we just do that for completeness? 224.
And then it says the penultimate paragraph on 224 might be important. You may also choose to accept the offer by signing the tenancy agreement and request to review its suitability.
Yeah. However, you'd be liable for the rent from the start date of the new tenancy regardless of the outcome. Yes, I see your point. My simple point to make on this one, I'm sure we'll come back and look at it, particularly in response to what I've written and a friend would say, is this is not a decision that an extant duty has ended. It isn't.
It couldn't be.
Quite. Quite.
They aren't sitting in a TARDIS, but what it does do is make it clear that if the offer is accepted, then the duty will be discharged.
It seemed, in my respectful submission, whilst those may be the words that are used, the effect of it is that it may be discharged. Because, of course, one of the submissions I'll have to make in due course is that decisions require notification, and the notification requires a right of review. And one of the reasons not to make that submission is to just test out this hypothetical. Suppose you accepted it, but issued a suitability challenge, as is very, very common, as we all know.
Yeah. Will it happen in this case?
Quite. The authority, on review, accept that it was an unsuitable offer.
Yeah.
That doesn't revive the duty. The duty never ended.
Yeah.
Because you can only make an offer, of course, of suitable accommodation.
Yeah.
Similarly, if one had gone to the county court after the authority upheld the suitability, the county court's decision wouldn't revive the duty. The duty had always existed.
Yeah.
So where the offer talks about will be discharged, what it actually means is may be discharged if the scheme of the legislation is complied with. Because you can't know at date of offer whether or not a duty will be discharged. It depends upon what happens subsequently.
Right.
What you can do is notify the recipient of the letter of your view that the duty has been discharged, and then they can review that in the usual way.
But this is just to anticipate the approach of the circuit judge. The approach of the circuit judge was, if you look at the scheme in section 193, there's nothing in 1936 about notification, and his approach was the effect of 1936C is that the duty was discharged by operation of law without any intervening decision by anybody. So I mean, you don't have to deal with that point now, but I'd be interested to know what you say about it.
And I will answer, and to really take the point against myself,
Yeah.
it's what my lord's analysis is about.
Yeah. I mean, obviously,
So
the facts
there are
involved
various
are
ways of
different.
skewering me. Yes, I appreciate
Yeah, no, I'm not trying to skewer you, but I would at some stage like some help about, you know.
So I'll flag it now and then come to my developable
Sure.
position. In my submission, everyone's starting from the wrong perspective. It's not 193C. It's 202 that's the critical one. 202 is the critical provision to understand how all this works. So it's not 1936 in isolation that tells you about discharge. You look at the scheme as a whole, And the centrality of 202, whether by necessary implication from 2023 and 2024, or by virtue of section 184, is that there has to be notification.
What can be said against that is, well, look, section 202 is very important because you're not out of time to ask for a review unless 21 days have passed from notification. But that doesn't import a duty to notify. That merely says you're not out of time to ask for a review on the face of it. So then you say section 184, and obviously it will be said against you that section 184 has nothing to do with it.
Well, and that's where we'll need to spend time again
Yes.
looking at the Warsame decision. Because in my submission, there's actually, designedly in the legislation and approved by this court in Warsame, there's a marrying up of 184 and 202. So you have to be notified of your 202 rights, and I say that is the proper reading of Warsame.
But there is a distinction between saying you have to be notified of your 202 right before you are out of time for asking for a review, on the one hand, and saying there is a duty to notify.
I understand that. Rather than deal with it now,
Yes, you're quite right.
this isn't the point that takes me by surprise.
No,
I do appreciate that's the molehill mountain, depending on how you view it, that I have to overcome. And I'll come to that when I deal with my two propositions. I do appreciate that is the arch I have to come.
Yes.
But in terms of part of my answer will start with 202, not with 1936. Carrying on through the chronology of it again, just jumping back to page 30. Yes, here the dates start to get slightly confusing, partly because of the coronavirus pandemic restrictions, and also it seems partly because of the difficulty that my lay client was plainly experiencing. It seems to me that it's probably actually on the 1st of April 2020 that my client signed the document entitling him to the grant of an introductory tenancy, and that's page 225 of the bundle. So this is the record of the grant of the introductory tenancy. You see at the top of the page it records consistent with the offer letter. It's a grant of an introductory tenancy becoming a flexible tenancy for a fixed term of 10 years thereafter. It gives a tenancy start date of the 20th of April 2020, but over the page on 226, you see the date of signature is 1st of April 2020. Nothing's going to turn on this in the scheme of things, but just trying to understand the dates here going forward. We know that my client doesn't move in, at least in part because the COVID restrictions were still in place at that time. And we also know that on the 4th of June, there's correspondence with his solicitor and the authority agreeing a new tenancy commencement date, and we find that at page 227. You have there the third paragraph, as you are aware, not possible to be a commencement date due to the coronavirus pandemic. Not strictly speaking, there does appear to be a commencement date, but it means an occupation date rather than commencement date. And you see in the next paragraph, taking effect from the 15th of June, conveyed to you by your solicitor. Deadline for acceptance of the offer being the 12th of June 2020. Over the page, I expect when you want me to refer to this, so I'll save them the time of standing up. If you fail to accept the offer, taken as a refusal of the offer, and the offer will be withdrawn. As you're aware from our previous correspondence, see there the offer of the one offer policy. Duty will be discharged. Third paragraph down, as explained in the letter of offer, right to request a review of suitability. A request a review up to 21 days to be notified of the offer. And then the final paragraph, counsel has discharged the duty previously accepted towards you under 1932. In such circumstances, which accept to terminate your right to occupy your present accommodation and will in due course seek possession of your temporary accommodation via the county court. On or around the 10th of June, it looks like a review request is made, and you find that at page 231. It's the second email from William Flack, dated 10th of June, to Miss Fraser Ellis. Mr. Flack asks the council to carry out a review pursuant to 202 in relation to the decision the property is suitable for him. Asks for it to be out of time on the basis that he's been unwell, he has difficulty providing with instructions, compounded by the coronavirus restrictions, and then 4 matters are advanced in respect of the suitability. Back on page 231, the top email on that page the authority agreed to consider that a review under section 202 outside of the time frame. Gives a deadline in the last paragraph. It was made on the 10th. Final decision is due by the 29th of July unless otherwise agreed. The middle paragraph, the last sentence of it, flagging the difficulty that's going on in the background as to whether or not Mr. Flack will be able to continue to act for Mr. Young. There's then clearly correspondence between Mr. Flack and Miss Ellis, because if we go back to page 229, we're now on the 12th of June, so 2 days after those emails we just looked at. You see Miss Fraser Ellis's email to Mr. Flack, recording an earlier telephone conversation the same day. Mr. Young considers he's accepted the final offer. Please find attached a tenancy agreement. Tenancy start date of the 20th of April, so that's the one we looked at, obviously. Then the discussion about the reality of the position because of the coronavirus restrictions. Council will arrange for the keys to 25 Diprose Lodge, which is the offered property, to be delivered next week. No rent until the 6th of July, which will allow Mr. Young time to make arrangements for moving in. He needs to return his temporary accommodation keys by no later than the 6th of July. He's banned from the housing department, so can he please return them via recorded delivery or dropping them off in the post box? 2 days later, on page 233, the 14th of June, Mr. Flack comes off the record. You see the bottom email on that page. Whereas Mr. Young will need to deal with you directly. Mr. Flack flags commendably in my submission in the paragraph starting in the event that if, as I suspect you realise would inevitably happen being an experienced housing solicitor, if possession proceedings are issued, please let Mr. Flack know he'll try and assist with retaining a litigation friend. Over the page on 232, sorry. Where's it gone? No, sorry, it's 236. I can't find the exact date, but it must be shortly after this email, because these are submissions that Mr. Young makes acting in person.
1st of July.
1st of July, thank you very much. Which then takes us to page 241. and the 20th of July review decision. We can skip over a lot of this because it repeats the history and then deals with the reasons that have been given challenging suitability, which don't need to trouble you in this appeal. It's page 251, paragraph 102 and 103.
Just noticing 247.
So if you're going to do that for me, if you start at 243,
yeah,
it refers to the email of the 1st of July. Paragraph 25.
Yeah.
So,
yeah.
My lord, on to the point about coercion. 247.
Yes, I mean, the letter says what it says. The allegation of coercion is not upheld, and it wouldn't be a proper one for me to repeat here.
No, and I'm not sure it's really worth going to it, but it
Is it
is
paragraph
the
61?
review officer going outside mere suitability.
Mr. Flack requested a review of suitability and advanced the 4 factors that you saw in the email. Mr. Young raised his broader, or at least additional, points to those raised by Mr. Flack. In my submission, it can't fairly be said that this is a review that goes beyond suitability. And I say that because of paragraph 1 on page 241. Where the author of the letter frames it as a response to a request for a suitability review. And in my submission, what the author of this letter is doing is treating the additional material from Mr. Young as further particulars of suitability. Because in my submission, that's what they say they're doing in paragraph 1.
And I follow the logic of that, but can you actually reconcile it with, for example, paragraph 68?
Mr. Young, having said, as he did in terms, that he'd been coerced into signing, the review officer plainly had to consider that. As poor as the point obviously was on its face, it seems to me it had to be considered. There's no authority for the proposition that you can disregard points simply because you think they're weak. They all have to be considered in 202. That doesn't change the nature of the request that was made. The request was a suitability review, and that's what was carried out. This is a peripheral matter that arose from the material Mr. Young had submitted. It's no different in my respectful submission from a situation where there'd been some inconsequential error in an original decision that's then corrected on review, named children is wrong or something like this. You have to deal with everything that's raised, but that doesn't change the nature of what was requested, nor, and you saw Mr. Flax describe suitability only, nor does it change the nature of what the author thought they were doing, which was making a suitability decision. And I should say, I do feel for the officer involved here, because had it not been addressed, someone in my position would have stood up and said, this is a defective decision because you didn't address it. So I do receive the review officer is in a very difficult position there. It's obviously not a good point, but it obviously needed to be addressed as well. That didn't change what the review officer thought they were doing.
So how, on your argument, Mr. Bates, how is the local housing authority to notify its view, if that's necessary, that the duty's been discharged by the acceptance of an offer of accommodation under Part 6? What is it supposed to do?
So it's relatively simple on my case. If you make a Part 6 offer to someone and they accept it, when the signed tenancy agreement is returned to the authority, by return they send out a letter which says, thank you very much for accepting the tenancy as offered. We consider section 1936 is now satisfied. 1936C is now satisfied, that being the reason. And this is the bit I do appreciate, I am asking the court to make some law, and that letter has to say you have a right to request a review of that decision. Not merely the suitability of that property, but a review of that decision, i.e. the decision that it's discharged.
And in the real world, I mean, I can quite believe that some local authorities, at least sometimes, send out letters saying thank you for your returning the tenancy agreement. We now consider our duty discharged. I'd be very surprised if any local authority really went on and said, and you have a right to a review.
Well, I find myself in good footsteps here because this is exactly the discussion that my lord had with Miss Davis, King's Counsel, in Banner, because I remember reading the decision.
It's a similar point.
But may I give a different answer to the one Miss Davis gave, which is, her position was, no, it does happen. The better answer is, if that's what the Act requires, then that's what the Act requires, because there will be cases, of which I say this is but one, where there is a dispute about whether or not it was sufficient to discharge the duty. I'm going to come to this in a minute. My reference, so what point? What am I trying to do? If the Act requires, as I say it does, I'm not going to shy away from this. I say all decisions require the notification of the right to a review. The fact that some decisions, of which I would accept the 1936C decision, is only going to trouble a review in very rare cases, doesn't mean that isn't what the Act requires. And one of the points I'll be making in due course is, look at the rest of 1936. A is where the duty ends because you're no longer eligible. But no one would suggest that doesn't have to be notified. And eligibility, as we all know, is one of the most Byzantinely complex areas. One imagines the right to review would be incredibly useful. But just to come back to paragraph 68 for a moment, maybe there's a further or even better answer that Laing Junior reminds me of. Paragraph 68, it is, in my respectful submission, the reason why you get to paragraph 102, the decision. Paragraph 68 is to the same effect as 102, 103. It's the finding that the duty has now been discharged. That's why you can get to the conclusions that are reached in 102, 103. This is not, as my learned friend suggests in writing, this is not a review of a discharge decision. The discharge decision is 102, 103 for the reasons given among others at 68. This is the first decision that the duty has been discharged. And the defect in this decision letter is that it does not tell the appellant, Mr. Young, of his right to seek a review of the decision that the duty has been discharged.
So just talking around that for a moment. Take an ordinary case where someone's offered accommodation, they accept the accommodation, they ask for a review of suitability, and the review officer says, no, I think the accommodation is suitable. You can't ask for a review of a review decision.
Agreed.
So insofar as the decision is simply a decision on suitability, you can't get a review of that, you have to appeal.
Agreed.
If the review officer says, because of my decision as to suitability, the duty is discharged, she has to say that that's susceptible to review?
Yes. Yes, because that's the first decision that the duty has been discharged.
So routinely, I mean, this must apply across the board almost. Nearly all suitability decisions are ineffective because I don't suppose anybody puts into a suitability decision you have a right to review. Therefore, the duty in masses of cases, historic cases, has never come to an end.
Well, it's not quite as historic as all of that, because pre-1996, of course, there was no review function at all. So I'm not quite going back into the myths of the
Quite a while ago.
There's two answers to that. One is, if that is what the legislation requires, i.e. notification, then yes, that is what the notification requires. But the second answer, the practical answer, which I think is what my lord is really driving at, and this is touched on in Ravichandran, what I'll try and take to when we go there, there's actually no reason why you can't stagger things so as to make all your decisions at the same time. There's no reason why you can't do two things at once, as it were. So you can do one that gives rise to a review and one that gives rise to an appeal. And we'll look at this in Ravichandran because this is...
And I follow that, but I mean, just in terms of practical consequences, there must be masses and masses of undischarged duties out there because there have been suitability reviews and the suitability decisions have not said you have a right to review.
There might be. I'm not going to shy away from all this. I do appreciate that one consequence of what I am submitting is that a commonly adopted practice is incorrect. Which is why this turns upon what does this statute require. Because the scheme of the statute, my lord and my lady know this, we've been sat in these cases. The scheme of the statute now is decision, review, appeal. And save for certain peripheral bits generally added by the Homelessness Reduction Act and some very bad drafting, that is supposed to be the scheme. Everything stays within the authority with a review by the county court. The High Court is supposed to have a very limited role, save for the mess that's been made with the Reduction Act. That's supposed to be the scheme of how all this works. Every decision that falls within 202(1) is one that in my submission has to be notified of the right to review.
I do follow your realism on this, Mr. Bates, but just following it through for a moment. So this letter, as one would expect, points out there's a right to appeal. So actually to fulfil their duties on your case, the review officer says, yes, there has to be, you have a right to appeal and you have a right to review. Sounds like a recipe for complete confusion.
It's not, I must mention, no, not really. It's simply identifying that you have different rights in respect of different decisions. That happens all the time. There will be some, as we know, thinking back to the exchange we just had, there will be some homelessness decisions that can only be challenged on judicial review. There will be some that can be challenged by review, some that can be challenged by 204 appeal. The fact that you might have different rights in respect of different decisions is no necessary reason for confusion. It's a reason for intellectual rigour to ensure that you identify what the decision is.
But the
and what the
recipient of
actual
such a
rights.
letter is all too likely to make a mistake.
Well, on my submission, of course, the recipient of this letter hasn't been told of an important statutory right.
So, but you say to do the right thing, you have to tell the recipient of the letter that they have a right to appeal suitability. And you have to tell them that they have a right to a review of the decision
Yes.
that the duty's been discharged.
Yes.
Well, not all recipients are represented by well-qualified lawyers. There's all too much scope for them then to do the wrong thing.
Well, we can look at how the courts have addressed that previously. There's a decision of this court, authored by Lord Newberger, will come to in due course. One of the, I forget the name of the British one of the many Tower Hamlets cases, about what happens where things have gone a bit procedurally wrong about that. It's not beyond the wit of the courts to cut through procedural errors. In my submission, though, what the error in my submission and the exchange that we're having is that it's overlooking what I say is the correct reading of 202, which is if all of those decisions in 202 attract a review right, you have to be told of that review right. What, again, I'm getting slightly ahead of myself, but one of the reasons for the change in homelessness practice between 77 Act, the 85 Act, and then the 96 Act we have now, almost all the case law focuses on the move from judicial review to Section 204 appeals. That wasn't actually the important change. The important change was the introduction of Section 202, the review stage, because before that it had only been something recommended as good practice in the Code of Guidance. The review is critical because it's the review where actually the homeless person has the best opportunity to put forward their best case. Because as we know, it's not constrained to exclude subsequent events. And we'll look at that, as we say in our skeleton. If I can take you to, yes, page 37, paragraph 26 of our skeleton. This is why 202 is so important. It's the only opportunity that you have to examine and revise the inquisitorial administrative decision that affects your most basic social requirements. 204 is different. By 204 stage, we're just shutting out the errors of law. We all know, in cases that we've argued, cases that we've sat on, that incredibly hard cases go into Section 204 and are lost because of the high barrier of error of law. This is why 202 matters. It's why the review is critical. It's your one opportunity to raise the factual minutiae that isn't going to be enough on 204. That's why 202 is so important, and that's why I don't shy away from saying, yes, the 202 decision has to be notified. And again, I don't shy away from this. If the current practice is wrong, it's wrong. Just coming back to the chronology, try and tidy this up, and then we'll come to the substantive argument. That was July 2020. November 2020, the 12th, is the service of the notice to quit. You find that on page 254. In my submission, that can't be any valid homelessness decision either, again, because there's no notification of any right to review. And we then get to the possession claim, starting at page 183. in the pleadings, and I'm not taking a pleading point here, this is to give us the chronology. It's paragraph 5F on page 188. The author of the pleadings at least read the review decision in the way that we do. The review decision was the notifying, I would say, that the statutory duty had been discharged. That's it. I'm not running into a stop or record point here. We need the answer to this question. But my simple point is, the author of the pleading clearly read the decision in the way that I say it should be read. That is the review decision is the decision that discharge has been achieved.
The word notify isn't used, the word that's used is
informed. I agree. I respectfully suggest that in this context, informed and notify are synonymous.
I see.
The defence is at page 175. And it's paragraph 3 and 5 that survive and make their way into this case. The discharge decision referred to in paragraph 5F was unlawful or requires no effect. Such decision cannot be made on review, must be made by a decision under 184. Defendant should have been given the right to request a review of that decision. By making a discharge decision on review, was unlawfully deprived of the opportunity to request a review of that decision. That remains our case. 4 is the capacity point, which ultimately we lose on, as I say, have to accept we had capacity to make the decision that we made. And then 5, the effect of the above is that the claimants continue to owe the defendant the full housing duty, and therefore eviction from the property without the provision of suitable alternative accommodation will be a breach of that duty.
And I assume by this point the accommodation that Mr. Young had accepted was long since gone.
I think that is right, yes. My recollection is there's some discussion about this in front of the district judge. It had gone quite some time ago.
Yeah.
And again, for the avoidance of doubt, I don't hold the authority for that. It's ludicrous to leave it open when there are other people to assist it. The reply is at page 167. The reply attempts to ride several horses, recognising the way the different arguments are going to go in due course. 2A, they deny that the decision to discharge was of no effect. The claimant was therefore entitled to discharge the main housing decision. But at 2C, the pleading makes the point that my learned friend now picks up on and advances that the main duty ended anyway. So both horses are being read. There was a decision, but if they didn't need to be, it ended at the operation of law. The district judge's judgment is at page 146. The substantive judgment starts at 149 because there's a relief from sanctions argument beforehand. As I said at the beginning, I hope the judge will forgive me if I don't spend much time on his judgment, rightly because it's a question of law on both sides, and so what matters is the legal argument that's advanced. The only point I think it's right that I draw out is on page 158. Starting at paragraph 34, Malernich Jr. argued that the offer had in fact not been accepted because of a lack of capacity. The district judge analyses the evidence of Dr. Suleiman, and what it comes down to, it seems to me, is paragraph 37. Dr. Suleiman doesn't say in terms there is no capacity to accept. And so it seems to me that what the district judge is doing is applying the usual presumption of capacity. There wasn't enough evidence to rebut that. there's been no challenge to that. I accept for the purpose of this appeal and for all of my argument, I accept we have to work on the basis that that finding or fact is correct. Finally, just for your note, as it's clear from the question sent from my lady that we've looked at this already, the circuit judge's judgment is at page 104. And again, given the way the argument is developing, I hope you'll forgive me, but so it's been read, and we'll come to the arguments in due course without descending to his particular view on it. Finally, again for your note, page 86, Lord Justice Newey's decision, judgment granting permission for appeal. I'm very grateful to Mr. Flight for chasing this down, for the transcribers for getting on with it so quickly. I was hoping to be slightly more encouraging, but it is there. So then let me turn to the substantive arguments. I said I was going to start with my own friend's last point, his so what point. And I think I should put this front and centre. What am I trying to achieve here? Because there is an oddity of the unappealed finding of capacity and the acceptance. And no appeal against the suitability decision. So what am I actually trying to achieve? I am trying to get Mr. Young back to the stage where he can exercise his 202 right to seek a review of the decision that the 1932 duty has ended. That is what I'm actually trying to do here. Because if I can do that, it seems to me there are two things I could do for him. The first is, someone could ask Dr. Suleiman whether in March or April 2020, on the balance of probabilities, he had the capacity to accept the offer. Because the point that District Judge makes is that no one asked Dr. Suleiman the right question. That's not challenging the finding that the District Judge can't do that. This is, quite frankly, cards on the table as to what I'm trying to achieve. I would like to have a chance to ask the doctor the right question. But secondly, even if he did have the relevant capacity, on review, what I would be trying to do for this gentleman is to get an intermediary to assist him to understand that his interests are best served by accepting this tenancy. And let me explain what I mean by that. Dr. Suleiman produced an updating report ahead of trial. And if we go to page 287, we see that updating report. It's paragraph 6.16. 6.16, which is at page 295. The difficulty Mr. Young has is he doesn't trust the counsel and he doesn't trust his solicitor. Dr. Suleiman expresses the view that we benefit from support from someone who can trust. And you might remember in the first report there was reference to a female friend who helped them cooking and correspondence. This is what he's driving at here. It has to be someone who's not employed by the council and has an understanding of his ASD and ADHD difficulties. If that person acts as intermediary, Mr. Young may be able to achieve the above. It may be difficult to find such a person in such a short period of time. It may be difficult to find them at all. Entirely possible. But I wouldn't normally be this blunt. Clients are entitled to make poor choices or choices I disagree with. But where he lacks the capacity and the official solicitor represents him, I can be more frank, I think, about what I'm trying to achieve. It does seem to me, reading the medical evidence, that if I can get him back in to section 202, there is a route by which this gentleman might be able to be helped to make what is obviously the right decision, which is to accept that tenancy and move in. That
would obviously have to be a different tenancy.
It would obviously have to be a different tenancy, barring some truly unusual thing about that property. That's the so what point here. Now, I appreciate none of that's for my lord or my lady. But it does seem to me that it was important to me to put my cards on the table as to what I'm trying to achieve for this gentleman. So it does look to me like there is a way that this man can be helped to get hands in.
So to speak, on your case, for matters to be brought to an end in the review appeal context, the local authority has to notify your client that it made a decision. No, they did that before.
Yes.
Has to notify your client that he has a right to review the decision that the duty had come to an end. And he can then contest the fact that he accepted.
He can contest the fact that the review has come to an end. So this is important to do it by reference to what's in 202. 202(1)(b) is a review of the decision that the duty has come to an end. So he would seek a review of the decision that the duty has come to an end.
But the basis for that would be, I mean, it did come to an end if he accepted. So on the face of it, he would be challenging acceptance, something that has been determined against him in the court.
I'm not trying to dodge the question. Given that my submission is the importance of the statutory wording, I'm coming back to the statutory wording every time. His contention would be that he's entitled to seek a review of the decision that the duty has come to an end.
Which means acceptance, or he's entitled to challenge acceptance of the offer.
I would accept that's within the scope, but what I would be asking for is the wording of 202(1)(b).
What else would be within the scope of the challenge?
Well, again, I'm slightly cautious about how far I tread, so, because I appreciate none of this isn't a pleaded argument in the county court. But for example, one of the things that does not seem to me to have been given adequate attention below, and this isn't a criticism of a junior or of my solicitor, I really struggle with why this man doesn't have a relevant disability for the purposes of the Equality Act, and why appropriate adjustments couldn't be requested. That could, one adjustment would be the intermediary that Dr. Sullivan notes. The absence of adjustments might be a reason why you could say something hasn't been accepted. Now, I can't ask you to make any findings on this, and I'm not asking you to. The reason I wanted to flesh out this point as to what I'm trying to achieve is that when I first read these papers, that was what struck me. There's a finding of fact that he had capacity to accept it and just didn't move in. That's what Lord Justice Newey struggled with as well. And it's what my learned friend says in the so what point. So cards on the table, that's what I'm trying to achieve. That seems to me, as far as I can tell, one realistic route to get this vulnerable man out. And that is what I'm trying to achieve. If I weren't acting for the official solicitor, I'm not sure I'd be quite so blunt, but I am. And that is what I'm trying to achieve with this man. And because of the way the litigation has developed, it seems to me the way to do that is for me to maintain the argument that I am maintaining. So coming then to the two propositions that I need to get home on, starting with proposition 4. Firstly, that Mr. Young had a right to be notified of the decision that the duty had ended, and of his right to seek a review of the decision that the duty had ended. I accepted in relation to my law this morning, I had to win on both of these. There has to be a duty to notify of the decision and a duty to notify of the right to seek a review. And in my submission, closing the appeal bundle for a moment and turning now to the authority bundle. In my submission, as I foreshadowed earlier, the starting point here isn't 1936, it's 202, which is in the authority bundle behind tab 1. On page 12. Before we come to its wording, I make two submissions of principle about it. The first submission of principle is as follows. Conceptually, this is one of the key provisions to understanding how homelessness law as a whole works. Not merely how 204 appeals work, but homelessness law as a whole. As I said earlier, in my submission, this is actually the really radical change that's made in 1996. Because before 96, you didn't have this right. You merely have a code of guidance exhorting local authorities to operate internal reviews. It's 202 rather than 204 that the really important ones are reducing the workload on the High Court. 204 just moves the venue for dispute from High Court to Court of Appeal. There's nothing for the volume of work. It's 202 that reduces the volume of work if it works properly. Because it's 202, coming to my second point of principle, that is the last opportunity for the homeless person to persuade the decision maker that they should obtain benefit that they say the legislation confers upon them. Paragraph 26 of our skeleton. 202 is your last opportunity for examination and revision of previous administrative decisions affecting your most basic social entitlement. Looking then at the wording of 202, a common theme throughout 202.1, 202.2, 202.3 and 202.4 is that there has to be a decision. Your right is to request a review of 202.1 any decision as to eligibility, any decision as to what duty, if any, is owed, any decision of steps to be taken under 189B, any decision whether to give notice under the unreasonable cooperation powers, etc., etc., etc. Without the decision, there is no review, because it's the decision that triggers the duty in 202.4. On the request being duly made to them, i.e. the request in response to the decision, the authorities shall review their decision. Now, the facts that give rise to the decision might happen automatically. The obvious one is eligibility. If for some reason you were deprived of your British citizenship, you would cease to be eligible. But you're still entitled to a decision to that effect, 202.1a, because you're still entitled to a review of that decision. And that structure in my submission, decision, which is notified, triggering the right to review, is what you see in all of 202.1. In particular, you see it in 202.1b. My right is to request a review of the decision by this local authority as to what duty, if any, is owed. I have entitled to request a review of that decision. That includes, as we know, a decision that circumstances have arisen which end the duty. So my right under 202.1b is not merely a right to review of an initial decision, but it's a right to request a review of a subsequent decision that a duty has ended. Now, I know this is well known, but my Lords and Ladies will forgive me. If I take you to the authority of that proposition, which is Warsame in the authorities bundle behind tab 8, page 137. And it's a G to H. The first question, it seems to me, is whether a decision by the local housing authority that it no longer owes a duty because some event has occurred which has caused an existing duty to cease is a decision as to what duty, if any, is owed. The answer to that first question is, to my mind, plain enough in the language that's used. It's plain at 2021b. It's directed at least part to the question of what duty arises. The phrase any decision as to what duty reflects the words of 1841b. That's going to be a very important observation to come back to in due course, because it's linking 2021b to 184, even though we know, because Warsame will decide this, that 2021b is not limited to initial decisions. Because one of the things that's said against me is that 184 is limited to initial decisions, and that's not right, after Warsame. Over onto 138. The paragraph plainly applies in that case. The language is apt also to apply to a decision that a duty once owed is owed no longer. A decision that a duty once owed is no longer owed is, to my mind, plainly a decision as to what duty, if any, is owed at the time when the decision is taken. So I am entitled to a decision that no duty is owed, and I got that. That is what the review decision does.
So strictly speaking, 705A is obiter, is it?
Which bit? Sorry, Mary.
Well, this was a case, I might have got the facts wrong. Is this a case in which the offer of accommodation was refused?
Did they refuse it? No. I don't remember. Let's just check. Yes, I think they did. I think that's right. Find it for my lady.
So head note's not terribly helpful.
No, I'm trying to find it for my lady.
I thought I picked up that they had refused, but I just wanted to check whether that's right.
The page 702, they notified the authority
Yes.
that the offer was refused.
Yes. I've just got that, yes.
So strictly speaking, this case, that passage to which you've just referred us, isn't binding on us as to the situation when an offer hasn't been refused but has been accepted.
I'm not quite sure that's right because of what happens in Ravichandran.
Well, hang on, I'm talking about this particular passage on its own.
Well, what was being what the challenge in Warsame was, the head note does get this bit right. It was a challenge to the decision that the duty had been discharged,
Right.
and that at least is our case as well. Would it be terribly impolite to park my lady's question for one moment and come back
I don't
to that?
want to disrupt. I know how annoying it is to have your submissions disrupted, and I really don't want to do that. I just want to raise the points I'm concerned about. That's all.
It's not annoying in the slightest. If there's something that troubles one of my lords or my lady, I'd rather know about it now rather than on receipt of a draft judgment. That's normally the worst time to discover.
I mean, that's the view I take.
So the point I'm trying to make here is that we know that 2021b encompasses a situation that I'm entitled to a decision that a duty that was previously owed is no longer owed. That's what I say we take from Warsame.
You say entitled to a decision, that's not actually what this decides, is it? It decides that if there is a decision, it can be reviewed.
Well, there has to be a decision. Authorities can't refuse to make decisions.
No, I mean, I don't want to get too much into Barno territory or Bano territory, I can't remember the correct pronunciation, but potentially you don't need a decision at the acceptance stage or indeed other stages.
So I suspect where my lord was going. I see you do, and I see you get that from Ravichandran. Even if there's only one decision that can be reached, because, taking Bano as an example, by operation of law, a state of affairs has arisen, there still has to be a decision to that effect. If we go to Ravichandran behind tab 13...
I mean, David, you don't get that, do you, from Lord Justice Chadwick? He is saying, if there is a decision, it can be reviewed.
I accept that. I still say that. Perhaps if I go to Ravichandran and take the passage I want to take to explain what I say you get from Warsay. It's behind page 250 of the authorities. It's paragraph 31 at C. That, it seems to me, the effect of Warsay's case is that the decision taken then, even if only complementary of prior automatic discharge, was reviewable under 2021B. That, it seems to me, is apt to catch the scenario that my Lord is putting to me. On my Lord's analysis, Bano is prior automatic discharge. It's a different kind of prior automatic discharge what they're talking about here, because the Bano legislation didn't exist. But my Lord's analysis of Bano, sorry, I keep saying that, this court's analysis of Bano through my Lord's judgment, is that it's possible to have, under the Housing Act, a duty end without more upon the occurrence of an event. And I say, but what you take that prior automatic discharge, the effect of Warsay, as understood in Ravichandran, is that you still have to have a decision. And I say that's right because of the centrality of 202.
Does it say that?
That's my submission as to what it says.
But where do you get that from? I mean, I quite follow if there is a confirmatory decision that's reviewable. But where does it say there has to be a further decision?
Let me yes, it seems to me. Yes, it seems to me we do get this from the passage in Warsay we were looking at. Go back to 138 in the authorities.
So we're back in Wasami.
Warsay, so yes. Would you practice pronounce it? Warsay.
I've always understood it's Wasami, but am I wrong?
I don't.
I always understood it was Wasami.
Decays to Kaiser.
That may just be me.
And I'm just getting muddled. At the time of Warsame or Warsame, whichever it is, what was the legislation in place?
That is
It's the original.
Housing Act 1996 as originally enacted,
So we've got it.
because they haven't changed it by
No.
2000.
Tab 2.
Yes,
Yeah.
tab 2.
Exactly.
There's
It's
no,
got-
there's no significant change until the Homelessness Act 2002.
So it's got the 7B.
Yeah.
So there had to be a notification.
There had to be notification, I accept, but there still had to be a decision to be notified. And this is the point I'm trying to get home on. It may, what I say you take from Ravichandran is that it may be that there is only one decision that can be reached, but it still has to be notified. A decision to that effect has to be made. Because without that, without the decision, you don't open the door to 202. And given that all of the decisions within 202, including the decision that a duty has come to an end, are reviewable, it just cannot be right that an authority can get to the position where they say a duty has ended by operation of law, but they don't make a decision to that effect or notify you of a decision, with the result that your 202 right, I suppose, never opens. That the whole scheme of 202, particularly if we look at 2023 in particular. Okay. 2023 on page 13 is not merely saying that there's a period of 21 days to exercise the right. It's telling you there has to be notification of the decision. It's doing two things. There must be an event, which is the notification of the decision, and from that event, the time period runs. And just taking it in my submission as a matter of common sense, if nothing else, how would one know from what date the 2023 right was running if there was no duty to notify? We end up with a variant of the absurdity my lord put to me, whereby there are undischarged 202 duties because it's no answer in my submission to say time hasn't started to run because there hasn't been any notification. Because that opens up the scenario that my lord put to me, was troubling my lord earlier, of undischarged decisions sitting there in the ether for years and years and years. The answer is every decision that could fall within 202 must be notified. Once notified, you have the rights you have the time period in 2023 and the duty in 2024. Also, that's also consistent in my respectful submission with the other parts of the legislative scheme, and in particular, section 184, 1b. So let's go back to 184, which is on page 3. The local authority have reason to believe the applicant may be homeless or threatened with homelessness, make such inquiries as necessary to satisfy themselves, ... whether any duty, and if so, what duty, is owed to him under the following provisions of this part. Once they complete that process, if you look at 1843, they have to notify the homeless person of the decision and any adverse reasons. And then note at 5, they also have to notify of their right to request a review under 202. (184) 1b, i.e. whether or not the duty is owed, and if so, what duty, is equiparated to 202 1b by Lord Justice Chadwick in, I'll do my friend's pronunciation, Osame, at page 137. So you see, it provides further support in my submission for the idea that there must be a notification and then the review right. 184 and 202 sit together.
So to be absolutely clear, you say, in relation to any ending of a duty, section 184 applies as such, with the result that you have to notify of your decision. If it's an adverse decision, you have to give reasons, and moreover, you have to notify of the right to request a review.
So the answer is yes,
yeah.
But I can't, because of the unhypothetical aeroplane, submit that for a Bannon case, because of what this court decided. I can submit it for a 1936 case, which is what this is.
but leaving aside the rights and wrongs of Bannock
Yes.
for a moment, how does all that fit with section 193?
So 193 is on. Let's take a look. Starts on page. No, it's the Welsh version. It starts on page 5. Now it seems to me we don't need 193 1A or 2 for the answer to this question because they're directed at different matters.
Can I just look again what they are?
Sorry, so 193, you've got page, section 193 on page 5. 1931 is the section applies where, essentially, you've met all the conditions. So you've got yourself within the scope of the duty, and if you come within the scope of that, then it's the 1932 duty to secure accommodation is available. 1A is a disapplication provision that doesn't cover us here at all. It's 3 where we start, which is about how we're going to end the 1932 duty. So these are the people that are owed the fullest housing duty.
The language of 3 is important. The
Okay.
authority is subject to the duty under this section unless it ceases by virtue of any of the following provisions of this section.
Mm-hmm. I agree, and I'll come on to the answer to this in a moment if I may.
Okay.
We can ignore 3B for the purposes of today's case. Restricted cases are certain categories of foreign national we don't need to worry about. We then look at the different ways the duty can end. 5 is the first one. So shall cease to be subject to the duty under this section if you're informed of the consequence of refusal or acceptance of the right to request a review of suitability, you refuse an offer of accommodation which the authority has specified as suitable for the applicant. It's not an offer of Part 6, so not social housing or private rented sector, and the authority notify the applicant they regard themselves as ceasing to be subject to duty under this section. This is now, in practice, only about moving people within temporary accommodation. Because
So-
you might,
How does that square with 184? 184 applies as well.
so I'll come to that one answer Banno if I may, because it seems to me that 5 is very similar to 7A.
Well, can we just pause on 5 a moment? 5 on the face of it sets down what you have to do in this situation. Do you also have to comply with 184? Because 184 goes beyond what is in 5.
Yes. My submission would be yes, because to submit anything else is to fail to appreciate the importance of 202. The reason why C has been made explicit when I say, of course, you get it from 184 is reflective of the fact that this is only moving people within temporary accommodation. I am the most particularly vulnerable cohort. So it's ensuring, without any shadow of a doubt, that the people moving within temporary accommodation are given fair warning of the fact that they are about to lose their housing so that they can challenge it.
But if 184 applies, you also have to give your reasons and notify of a right to review.
Yes, that is my case.
So why isn't that in 5? Why has Parliament said one thing in 5 and another thing in 184?
Part of the reasoning, although I appreciate this is unlikely to be the argument that finds favour, part of the reasoning is the frankly appalling state that this part of the statute book has got into by virtue of being amended so many times, still with so many things. With 1935 as a particular example, now effectively confined only to temporary accommodation. It's not in my submission any evidence of a conscious parliamentary choice. It's simply a consequence of repeated, badly written amendments.
But how can we divine parliamentary choices other than by looking at the words which Parliament has and hasn't used in different provisions?
Well, we certainly interpret this legislation as a coherent whole. that I don't think is remotely controversial. How might that might be in dispute. So we start in my submission with 202 because that's the big conceptual change between the old homelessness law and the new law. That's why we should start with it, because it is the big difference between modern homelessness law, I can call it that, and old homelessness law. It is central to the proper operation of the scheme because it is how you actually stop people ending up in litigation. In order for that right in 202 to make sense, to work for both local authorities and the homeless, there has to be, in my submission, a duty to notify of that decision. Where do you get that duty from? You get it from, in my submission, 2023, 2024, or 184. They're all pointing the same way.
I mean, the alternative view
Yes.
Section 184 is dealing with a completely different stage of the process. It's headed Inquiry into Cases of Homeless or Threatened Homelessness. That's where you start. And Section 193 deals with where you've moved on to and lays down specific rules as to the particular circumstances covered by Section 193.
So I say there's two answers to that. The first is, that is a difficult argument in my submission to maintain when one looks at what was said in Warsame about marrying up the language of 184.1b and 202.1b. 202.1b was said in Warsame to be effectively the other half of the coin of 184. And if 202.1b includes decisions that duties that were previously owed are now no longer owed, 184.1b must include decisions that duties were previously owed were no longer owed. The two phrases can't mean different things in different parts of the statute. If that's right, then it means that the notification duties in 184 apply to all of the decisions. They certainly apply to the decision that I'm focusing on in this case. The second answer, if I may, is we'll look at let's come to 196 then. I haven't been hiding it away, even though it's the central position for this case. I accept, and we accepted in the skeleton, 196 does not have in terms.
Sorry, 193.
1936, sorry, 1936. Sorry, I'm as bad as the draftsman. 1936 on page 9. I accepted in the skeleton. 1936 does not say in terms anything about notifying anybody of anything. But let's just look at it and ask ourselves if that can really be the correct interpretation. So the authority ceased to be subject to the duty if the applicant ceases to be eligible for assistance. Is it really the case that you're not required to be notified that the reason why you are to be put on the streets is because of a change in your immigration status? Is it really the case that you should be expected to guess that you have a 202 right in respect to that? Because you must have a 202 right in respect to that, because we know that eligibility cases come up all the time.
I mean, in the real world, it wouldn't happen like that, I suppose. I mean, the local authority wouldn't keep to itself the fact that it's decided you were no longer eligible. It would decide to do something about it. And when the recipient of the communication that they decided to do something about it learned that, they could ask for a review under 202.
Because in any event, there's no problem about this bit of subsection 6, because section 202.1a expressly says that you've got a right to request a review of any decision of the local authority as to his eligibility for assistance. So what 6 is doing is simply telling you when the duty ceases, and it is not making any specific provision about notification. So, unlike 5 and 7, so if there is a duty to notify, it must be found somewhere other than 6.
I agree.
But
yes.
but it must be an express duty to notify,
So-
because that's the scheme of 202.
So I agree that it's not found in 1936. So of that I have no difficulty at all.
Well, it's completely absent from 1136.
Quite. One simply reads it, it's not there.
Right.
So that's why. So where does it come from? And that's why I say there are two places it comes from. The first is 202 itself. It does not make any sense in my submission to suggest that there is this revolutionary new right to an internal review, your last opportunity, as I say, to persuade the authority of those personal, factual matters before we get into the hard-edged world of 204 appeals. It makes no sense for that right to be created, but you not to be told it exists.
But that's where I say it's unreal. If you take eligibility, I mean, if the local authority concludes in its own head that you've ceased to be eligible and does nothing about it, the tenant isn't affected. At the point at which the local authority says, we don't think you're eligible, therefore you have to leave, or whatever, at that point, 202 bites. There's no question of the person being out of time because he hasn't previously been told of the decision. And he can apply for a review under 202.
But respectfully, how are they to know they have the 202 right? The only place they're told, the only place the statute requires you to tell the recipient of their 202 right is 1845. So it would be lawful, on the scenario law puts to me, it would appear to be lawful to make it, to conclude, to put it neutrally, that a decision is that a duty is no longer owed because of 1936A, as a matter of administrative convenience, but nothing more, to send a letter to that effect, and then leave it to the recipient to work out whether they have a 202 right.
I agree that follows, but that on the face of it follows in relation to 5 as well, because 5 doesn't say you have to notify of the right for a review. It says you have to notify of the decision.
And that's why, as I say, I accept I do have to go further than the case law has done so far and say there is a duty to notify of the review. So where does it come from? I say it either comes from 202, 3 and 4, or it comes from 184. The answer, on 184, the answer can't be this is only directed at the initial inquiry stage, because we know that the wording in 184(1)b is apt to include things that have happened potentially years after the inquiry stage. So the argument against me on 184, if it relies, as my lady put to me, on the heading of the section just about inquiries, etc., that's giving a heading weight it won't bear. The scheme of this legislation, in my respectful admission, is each decision has to be notified and tracks and has to include notification of the 202 right. I, of course, accept 1936 does not say that. I cannot point you to 1936 Roman 2 to that effect or anything like that. But we have to interpret the scheme as a whole. And that's why I say I started with 202, because of its centrality, because of its importance to homeless people.
And to be clear, I know you're going to come on to this, so I'm taking you out of your course. When you come to 7, refusal, 184 bites, even though Parliament has specifically taken away the notification provision.
Yes.
Well, why did Parliament take away the notification provision?
Because 184. You don't need it twice.
Even though you've got it in 5.
Well, 5 is telling me that they regard themselves as ceasing to be subject to the duty. To get my notification of my 202 rights, I still come back to 184.
I mean, what you used to have to do was notify that you thought it reasonable and that the accommodation was suitable. You didn't have to notify of the right of review. Is that not comparable to what you get in 5?
Well, I said you did have to notify because I say 184 has always had that effect. But respectfully, I do slightly caution about doing forensic archaeology of the older provisions here. The last time there was a coherent reform of homelessness law was the 1996 Act. What you've had since then are a series of piecemeal changes. the Homeless Act 2000, 2000 I think it is, expanding the use of the private rented sector. The Localism Act taking away people's rights to object to being discharged into the private rented sector. There's a tail wagging dog danger here in my submission.
I do see this. Can we just look at the old provision for a moment? This is behind tab 2, isn't it? The old one, section 193.
Old 193, yes.
So in the old section 193, one had ceasing to be subject to the duty and the authority notifying that they regarded themselves as discharged. And then in the old 7, you also had ceasing to be subject to the duty if be satisfied, blah, 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 and notifying.
Yeah.
So you had 2 notification requirements, 1 in 5 and 1 in 7. Now, if Parliament had thought, well, we don't need to include notification requirements in section 193 because it's catered for by section 184, you'd have thought they'd have taken out the notification requirement in both places, and they didn't do that. They kept it in one place and they took it out in the other place. So why?
I don't know is the short answer. I have spent quite a lot of time reading all your policy papers again.
But aren't we sorry to interrupt, but aren't we entitled to draw an inference from the fact that that amendment has been made and that that provision is no longer in there?
Well, I think it depends what we're looking to draw. And it's the question of how we're approaching this question of statutory interpretation. There's a reason I keep returning to the centrality of section 202. Because if you're not with me on that, it's not quite that suddenly I'm building on foundations of sand, but it gets a lot more difficult to maintain. In the absence of authority that compels you to find a particular way, and the Vernon from Dry says there is authority that compels you to find a particular way, we take this from first principles. I say, you start with 202 because of its centrality to the scheme and to the homeless person. 202 only makes practical sense if people are notified of their rights. And that benefits both the authority and the homeless person. It benefits the homeless person because it gives them access to that last opportunity before they end up on the hard-edged world of points of law. And it benefits the authority because that's how they know when the time limit starts to run. In my submission, the cases that have looked at this, and I include Barrow in this, as perhaps a criticism of how it was argued. 193 isn't where you should be looking for this. You look at the wider scheme. It's striking that in Bano, from what I can see, no one made any reference to section 104. If we accept, as it seems to me that we must do on the current state of the law, that all of the decisions in section 1936 are capable of being reviewed under 202, and they are all capable of being reviewed under 202, then there's only 2 choices. Is there a duty to notify someone of their right under 202, or not? The fact that 1936 doesn't say anything about duty doesn't matter if I'm right that you can find it in 184 or 202 itself. And that's what this comes down to. That's part of the answer to why I say I can distinguish Bano. I'd like to be somewhat freer, but I accept I'm not.
and indeed, whatever we might think, we're not free either.
No, quite. But Bano, I think, is not the answer to this, because when you look at the 7AA down to 7AC cases, there is some provision for notification in there. It's possible for me to say Bano doesn't matter because Parliament made its own provision about internal notification in there. Now, I go further. I do say, and I'm happy to say, every decision gets 184, but I can be wrong about that and still win this appeal, because there's another way of grappling with Banner at this level. 1937AA exec and 1935 do have provisions about notification within them.
But actually, you do need 184, don't you? Because it's only from 184 that you get subsection 5, the duty to tell of the right to request review.
I probably do need 184. I mean, it's striking that in Banner there's no reference to 184. I have no idea how it's argued. It's only in the Housing Law Report, so I don't know what the arguments were. But for the purposes of the argument I'm advancing today, Banner isn't determinative. The question on our appeal today is, are we right that there is a notification duty coming from 20234 or 1845? If we're wrong about that, that's the end of it.
Yeah.
There's one other point on Banner I think I do need to deal with, and then I'll just turn my back on the first proposition if I may, and try and finish the rest of the argument. I think it's paragraph. Yes, we've probably covered this already, but for completeness, it's paragraph 60 on page 544. And it's point C. As I say, my lord writing for this court makes the point that nothing in 193 or 202 makes the right to request a review having been conditional on the appellant being informed of the right. It seems to me that's probably right, because if the right exists, it must exist. But in my respect for submission, that's almost to miss the point. The right in 202 doesn't exist in a vacuum. It exists to be exercised. How do you exercise it? Well, you exercise it by being told about it. The answer to the question of statutory construction can't be, in my submission, that with access to housing lawyers, you can work out what your rights are. A, there aren't enough of them, and B, it's quite hard to sleep at some stage. I know he's important, I'm sure he'll forgive me. He has quite frankly gone above and beyond the call of duty in this case. It is a remarkable testament to the commitment of legal aid lawyers. I'm sorry, he didn't know I was going to do that, but I think it's entirely right thing to say. But we can't run the scheme on that basis. How do we run it? We run it with the decision maker saying, I've made a decision, you have a right to review it, which you do as a matter of law. And I'm telling you about it, and if you want to exercise it, send the email to this address, or this officer, or this phone number. You've got 21 days to do it. So if you're going to get some more evidence, you better get on with it. And that brings me to the last point on this proposition. A point my lord's put to me, and a point my friend takes in his skeleton. I completely accept that it's a legitimate approach to the interpretation of this statute to try and ensure a simple, workable scenario. This is about providing rights for vulnerable people and an easily administrable scheme. It's not about creating work for lawyers. My scheme doesn't create those problems. My scheme is very simple. Every decision that can be the subject of a 202 review attracts the right to be told about that. Because without being told that, how do you know? That then was my proposition 4, so I'll come back to my proposition 3 now. Assuming I'm right about that, and assuming there hasn't been notification of my 202 rights, what difference did it make in a possession claim? Did I have a public law defence? It doesn't seem to me there's a lot between us on the availability of public law defences, in principle how they work, Kay and Lambeth, and the proposition that it extends to the full range of public law arguments, not merely Wednesbury. What it really comes down to is, seems to be twofold. What was my defence, and was it open to me? So what was my defence? If I can ask my lord and my lady in our skeleton argument to go to paragraph 16. Our position is that if we have not been notified of the right under section 202, the duty has not been discharged. The 1932 duty is, as Imam al-Kundi, as it's called in Scottish, to the same effect. It's an immediate, non-deferrable duty. It's frequently enforced by mandatory order in the High Court. To put it bluntly, someone who's owed the 1932 duty cannot be on the streets.
And just reversing to where we were a while ago, this is not actually an issue in the case. Do we take it that even by the time the notice to quit was served, the other accommodation was no longer available to Mr. Young?
I think that is right, but if I'm wrong, there are lots of people with better memories as to what's happening below will correct me, and I'll correct you with the short adjournment. I think it had gone in pretty short order.
Yes.
Which would also fit with common sense in this court's experience of authorities and the demands upon them.
Yes.
And if the effect of possession would have been to put him on the streets, then we say that would have been an unlawful act. The defence in my submission, in the appeal bundle, gets it completely right. At paragraph 5 on page 176. An eviction from the property without the provision of suitable alternative accommodation would be a breach of the duty. It can't be, and I'm anticipating what said against me, it can't be a duty to stay in this property, because you don't have that under Part 7. You have a duty to be provided with accommodation of a particular description.
I mean, if it helps, I'm not contesting this point, because the reason that was given, stated in the particular claim, the reason we are seeking possession is because the main housing duty has ceased. So, and I'm specifically not relying on
You're
what
not
you
suggesting that
It's
you
on
were
Judge
offering an
Saggerson.
alternative.
No, quite. That was the reason. Now, His Honour Judge Saggerson was persuaded we might have reached a decision to seek possession in any event, but I'm not relying on that. So my learned friend can pass on to
That's very helpful, and it's a very polite way of my learned friend telling me to get a move on, I think.
Not at all. I'm just trying to help you meet your self-imposed deadline.
For completeness, that's also the way Lord Justice Newey approached it in the decision journeying permission to open court, page 91 for your reference. So the real question is this available to me at all, or did I have to take this by way of section 202 review? So, pausing here for a moment, in my submission there is a tension between the arguments my learned friend here makes about the primacy of section 202 with the position that he took in relation to my proposition 4. It's rather difficult in my submission to make the case that where my client was not told of his right to a section 202 review, that the decision that the duty had ended, the failure to exercise a right you were not told of means you can't now take the point as a defence. It seems to me there is a difficulty, a conceptual fairness difficulty in how my learned friend puts it. And if my learned friend is right, that an extant duty cannot give rise to a defence in possession proceedings, then in my submission that provides another very strong argument as to why I'd be right about the importance of notification under section 202. It can't be both ways. But be that as it may, I say there's no bar to taking this as a defence to a possession claim. We approach this part of the argument in quite different ways. So let me be clear about what I'm not saying. I don't dispute the general proposition of law that statutory remedies are to be preferred to invoking judicial review. I don't for a second dispute that a statutory suitable alternative remedy should be used before judicial review. As bold as I may feel, there is no point challenging that submission. That is now so settled law as to be tried. But that gives rise then to two questions. Firstly, does section 202 and or 204 actually exclude taking these points by way of defence? I'll take this quite blunt, quite shortly. No. 202 and 204 have nothing to say about what you can and can't take by way of defence. The position is, as we cited in Winder, in our skeleton, you need clear words to exclude the general rights. Parliament is well versed in creating those clear words. It's had a lot of practice since Annis Minnick onwards. You don't find them in section 202 or 204. That's not a surprising submission position in my submission, because they're doing such different things. 202 is, as we say in paragraph 26 of our skeleton, it's that chance for the last contextual, holistic, factual, personal circumstances-based review. It's about my lord, sorry.
No, but can I just test how far you go? Your second proposition may explain how far you go, but just in advance of that. So take a very ordinary case where somebody turns down an offer, asks for a review of suitability, but the local authority impatiently jumps in and brings possession proceedings, and miraculously those possession proceedings come before the court before any suitability review has taken place. Now, it would be staggering if a district judge decided to make a possession order in advance of the suitability determination. But would it be open to the disappointed homeless person to say, look, you know, let's deal with suitability in the court now?
By way of inviting the district judge to hold
that the local authority had not offered suitable accommodation, therefore the duty continued.
So by way, but by way of what sort of process? As in a full merits hearing? So yeah, better than you'd ever get on 204?
Absolutely.
Or conduct 204?
No, full merits hearing, because you say the existence of the review procedure doesn't exclude the possibility. Nothing in section 202 says you can't argue about these things in the county court. Therefore, it's open to the defendant to say, court, please determine suitability. There's no problem with that.
So in that scenario, the answer is to refer the district judge to Hamlets and Bagan, which is in tab 11 of the authorities manual. Because that's the decision of this court which has grappled with that scenario, and it has two answers to it. So if we can go to tab 11, and this is my second proposition. So yeah. So in this case, Hamlets and Bagan, sorry. In this one, it's superficially quite similar to us. Homeless person had refused an offer, but hadn't asked for a review or appeal to the county court. What they had done is put in a defence to a possession claim that argued the section 1932 duty had not been discharged. And if we just jump quickly to the head note, page 204, in the pages in the bottom right corners. 19, 20 and 22 give us the facts of this case. So she rejects the offer with reasons. The authority tell her that she has no further right to review, but she could appeal to the county court. She doesn't ask for review, she doesn't leave. They issue possession proceedings. The DDJ finds the 1932 duty hadn't been discharged because there hadn't been a notification provision. Circuit Judge 21 we can put to one side. He got dragged into what was then the endless debate about what Article 8 had to say about these cases. And at age 22, she's put in no evidence as to why she didn't review the decision or appeal to the county court. And the answer in that situation, said Justice Newberger, writing for this court, is what's recorded at age 28. There are two answers to that scenario. Firstly, you could treat the grounds for resisting the possession claim, i.e. the defence, as an appeal under section 204. You would then have to proceed as if she was applying for permission out of time. Alternatively, come down 3 lines, he did leave open the possibility of there being exceptional circumstances allowing it to be taken as a defence in its own right. And that, the head notes reverse the order in which his lordship makes his decision. If you go to paragraph 33 first. Paragraph 33, it seems to me, is generally supporting the primacy of going down the 202-204 route, but it does leave open the exceptional circumstances point. So, just look at 33. It doesn't find it would be impossible to take this point, it simply says that you would expect it to be taken by way of 202 and 204.
That slightly cuts against your earlier submission, is that there's no express ouster clause, and you didn't need to be for the reasons that Lord Justice Newberger, as he then was, gave in paragraph 33.
Well, it's always a question of construction. I'm quite contented with the way Lord Justice Newberger, as he was then, puts it here. I'm quite content with the proposition that generally 202, 204 should be the answer, but there is. And there remains the residual exceptional cases. And that's why I was making the point no ouster clause, because once this court's decided that there is the exceptional case, that's because there is no such ouster clause.
Right.
Because my learned friend advances it, and I understand why. He advances it rather more starkly than it's presented here. He says, suitable alternative remedy, that's it, normal approaches to this, you had to do it. I say that's wrong. The binding authority is it's at least possible in an exceptional case to take it as a defence. But the better option is the one that Lord Justice Newberger takes at paragraph 40, which is treat it as an out of time section 204. So the answer to my Lord Justice Newey's question is it is possible for a judge hearing a possession claim in the county court to do something, because Lord Justice Newberger says it is. It will have to be exceptional circumstances. Quite what he does, and the difference between merits and the judicial restart hearing, maybe for another day, certainly it's not 15 minutes to get into, is not necessarily the best answer. But those are your two answers to it.
But if you treat it, I'm so sorry to cut across you, Mr. If you treat it as an out of an application for permission to appeal out of time under section 204, suppose for a moment the application for permission to appeal out of time is allowed, you're restricted to errors of law, aren't you?
You would be, yes.
So you couldn't go into the points you were making about capacity and all of that.
Well, unless I had evidence to show that as a point of law, there was no capacity. But I accept the point you're putting to me.
But that would have to be founded in some evidence.
Agreed. Yes.
Okay. Well,
Yes. If we go down the route that Lord Justice Newberg identifies in paragraph 40, that has to be a traditional Section 204 appeal. It can't be some strange hybrid.
No, so it can't go into the factual merits.
No, exactly. Traditional 204. Authority is primary finder of fact, subject to the hard-edged error of law.
Yeah.
But that's why on opposition 3, is there a hard-edged suitable alternative remedy point? The answer is no. It's been decided. If you have problems of the sort that happened in Tower Hamlets and happened here, you can take it in an exceptional case. So the question becomes, what's exceptional about it in this case? Well, we come back to the failure to notify us of the 202 right. There's almost nothing between the learned friend and I in all his cases on procedural exclusivity. I simply say it doesn't arise here because it's been decided at this level that the two options are open to you, albeit one is exceptional. Just for completeness, the exceptionality test, rather than the out of time 204, appears to be what was approved by this court in Godson. You go to tab 23. Lord Justice Lewison now writing for this court a very similar factual scenario. It's paragraphs 21 down to 25. You'll see he approves paragraph 33 of the Tower Hamlets case. Paragraph 24, debate whether it was ratio or obitive, but it was plainly right. I have to say, I don't read him as saying that paragraph 40 is therefore wrong. I simply read him as having stopped at paragraph 33 and said, well, there you go, there's an answer to why Miss Godson can't raise it in this point. And for completeness, Banno doesn't touch on this argument. Godson was cited, you can see it in the list of cases. Godson was cited, but it's only cited in argument rather than referred to, so I suspect it was one of those in passing points. So the answer on proposition 3 of could we take a public law defence is yes, because the Tower Hamlets case says we can. It's not open to this court to say that you had to bring it by way of 202, 204 because of the Tower Hamlets case.
I mean, that's what was said in the Tower Hamlets case, isn't it?
I think that's right. Go back to it.
If you look at paragraph 35, the judge ought to have asked himself whether it was too late. And paragraph 40, he would have been bound to conclude that it would be wrong to allow the respondent to appeal so long out of time.
Yes. With one eye on the clock, I'm looking to bring this to a close now, because I can come back in reply if there's more to explore on it. But that's why I say proposition 4, this strict demarcation of the arguments 4. You might be right about that, but not in this court. Even though I say proposition 3, I might be right about that, but not in this court either. So just pulling all this together, and I end hopefully where I started. My position is that we were entitled to be notified of our right to seek a Section 202 review of the decision that the duty had ended. We have not been notified of that. That is a public law error. The duty has not yet ended, and we were entitled to take it as a defence. My lord and my lady will give me just one moment. My lord and my lady and my friend are very, very patient with me and very helpful finding page numbers. So unless I can help you with anything else, I have managed to finish within time.
Thank you very much, Mr. Bates. Mr. Hutchings.
Yeah. So I've got about just over 10 minutes. So what I'll try and do is just engage in an overview. So first of all, my submission is that it is ironic that my learned friend is running a case, firstly, on the construction of the legislation, that the notification of a right to review a discharge decision is a crucial element in the scheme, which he says is missing from section 193 and supplied by section 184. And secondly, that the suitable alternative remedy principle does not apply because the appellant did not have a fair opportunity to challenge the discharge of duty. In essence, for the very same reason, he says the appellant did not get a notification that he had a right to review the discharge decision. So all that is rather ironic, because on the facts, what happened was that the respondents made the appellant an offer of accommodation, which told him he had a right to request a review expressly of suitability on a fair reading also of the discharge of duty. And moreover, his solicitor and or he himself requested a review that went beyond suitability, included the discharge of duty. He then got a review decision, which was in my nomenclature a discharge review decision, which expressly told him he had a right to appeal to the county court and of the time limit for doing so. So my learned friend submits, just to go over it again, firstly, the crucial element that is missing from section 193 is the applicant, where is the provision that requires that the applicant is notified of his right to request a review? That's his essential point. And you have to examine that against the factual background that the system worked. And secondly, he says he's not troubled by the suitable alternative remedy principle because he wasn't given that fair opportunity, whereas in fact, he took it. So there is a disjunct between my learned friend's submissions on the law and the facts. And I'll be submitting that if you look at the facts, in essence, in this case, the local authority didn't make the mistake that Lewisham made in Ravichandran. I'm not saying the procedure was perfect, but it was near enough. To the correct operation of the statutory scheme as envisaged by the Court of Appeal in Ravichandran. And that, if that's right, that's really an end of the case. It wraps it all up together. But I do accept that the relevant provisions of the Housing Act 1996 are not crystal clear. And that's probably due to a confluence of factors. One is that Part 7 of the Housing Act 1996 largely reenacted Part 3 of the Housing Act 1985, which itself was in essence a reenactment of the Housing Homeless Persons Act 1977. So we can have a little look at that. And I also accept my learned friend's point that the relevant provisions have been amended piecemeal. So we've got a situation where we've got historical legislation with case law codified to some extent, in particular in section 193, and then we've got piecemeal amendments. So it's a bit of a mess. It's not crystal clear. I accept that. But what is common ground is the proposition, because we haven't provided you with N3, but from the Supreme Court, but it's common ground, the proposition at paragraph 41 of my skeleton argument, that the modern approach to statutory construction is to have regard to the purpose of the particular provision and interpret its language so far as possible in a way which best gives effect to that purpose.
I have a little bit of difficulty with that proposition because where does the purpose come from if not from the language?
I can see the force of that, my lady, but there is a difference between, so in a contractual context, between a literalistic interpretation of words and then looking at the scheme of the contract. And so it is with legislation, that if one looks at the scheme of the legislation, that may illuminate the purpose in a way which a detailed syntactical analysis of individual provisions may not. Is that a reasonable answer?
Well,
or it doesn't satisfy regulation?
I'm still struggling with it because if the words aren't there to achieve whatever end a litigant is aiming to achieve, how does the court just magic those words out of the ether in order to achieve a broader purpose that somehow I mean, I just find it very difficult.
Well, a recent really quite striking application of that approach is, of course, the Wathen Fayed case in the Supreme Court about the Crematorium Act 1905. I don't know if you're not aware of that. So where the Supreme Court concluded that the same words had a different meaning in two adjacent sections, I might exaggerate slightly, of the same act, having regard to the history of the legislation in order to make it make sense. So there is a difference. I mean, I accept your ladyship's point that one is looking at words, but one approach, and perhaps a traditional approach, is very literalistic, and
Well, there's a difference between being very literalistic, as I'm trying to explain.
Yes.
My difficulty, and discerning a purpose for which there is no evidence in the text that Parliament has used.
No, so in this case, I'm not relying on any material outside the text, but I am inviting your lordship and your ladyship to look at the structure and general purpose of the legislation as it appears from the text. Is that a reasonable answer?
Well, that makes more sense to me. You can discern general purposes from other provisions in the Act. My only difficulty is with this apparent idea that you can. Anyway, yeah.
No, I quite agree with your ladyship's point that one shouldn't start construing an act with a preconceived purpose. That's wrong. There has to be some basis for defining the purpose. But I think the idea which underlies that approach is one which says we're going to look more at the structure and overall aim of the legislation rather than a detailed syntactical analysis of a particular provision, or at least both go into the mix. And that's particularly so where it's really common ground that the relevant provisions are not drafted with crystalline clarity. I wonder if I have enough time to just deal with the so what point. Or do you
try that?
Shall I try that?
Yes.
So my learned friend initially advanced two propositions. There was some purpose to the public law defence. First, his first answer was that if there was now a Section 202 review, the appellant might be able to advance evidence that he lacked capacity. Now, I was a little surprised by that because my learned friend and I are both aware of a decision of this court in B and W District Council. And if I just tell you briefly what it is, if an applicant lacks capacity to accept an offer of accommodation, no duty is owed under Part 7 of the Housing Act 1996, unless he has a deputy appointed under Section 19(6) of the Mental Capacity Act 2005 to make the application on his behalf. That proposition originates from a decision of the House of Lords in a case called Furdus Begum, which is more generally known as the Crown, under the name of the case, the leading case, the number 3 cases heard together, the Crown against Oldham Metropolitan Borough Council ex parte Garlick. So in that case, a House of Lords decide if you don't have capacity, you can't apply as homeless, you have to go down the social services route. Today, that would be the Care Act 2014. So in terms of the skeletons, I referred to this case in my initial skeleton. There was then no reference to capacity in my learned friend's skeleton. We agreed we'd just have 2, so to save you looking at various different skeletons, and he would go first. So I'm a little bit surprised he's trying to revive it. I thought he'd taken the hint that capacity, lack of capacity, was always a bad point. So what actually happened in B and W District Council was the county court judge hearing the appeal decided no capacity, so no duty. So that's a bad point. The second point was that if there was a further review in some way, the appellant might be able to accept the offer. But that's wrong, because even if my learned friend is right and the review decision of the 20th of July 2020 was an original decision that the duty is ceased, and the appellant has a right to review that, he's already accepted the offer. The duty is already ceased. He doesn't get another offer. That only happens if he was successful in his suitability review. And he's not saying that there's any reason to revisit that. So that's a bad point. I think eventually, when questioned by your lordships and your ladyship, he said, well, actually the answer is, and this was the third point, and I do have experience of opposing counsel having been cross-examined by the Court of Appeal into a point which eventually won the entire case. So I'm not suggesting against me. So I'm not suggesting that's in any way makes this point invalid. But he said that there should have been reasonable adjustments in terms of the way in which the respondents operated their procedure. The difficulty about that is that on the facts, there was a review, and it was never suggested at the time that there should be any reasonable adjustments. So these are all, in my submission, all hopeless points, which means that the public law defence would have made no difference to the outcome and therefore fails in any event. And that leaves after lunch to deal with the more interesting points, which are about the correct decision-making procedure under Part 7 in relation to discharge decisions and how the suitable alternative remedy principle applies in this case. And it may be, in the light of what my learned friend said, has said that there's not an awful lot between us in relation to the law on the suitable alternative remedy principle. It may be it's just the application to the facts, and it may be that everything ends up turning on the first point.
That's a good moment to break. So 2 o'clock.
All rise.